الحمد لله وكفى وسلام على عباده الذين اصطفى أما بعد فإن أصدق الحديث كتاب الله وخير الهدي هدي محمد صلى الله عليه وسلم وشر الأمور محدثاتها وكل بدعة ضلالة ثم أما بعد أيها الأحبة الكرام السلام عليكم ورحمة الله وبركاته. Inshallah, before we start talking about or discussing the business transactions, inshallah, just a point worth of mentioning, which is related to the salah. And if you enter the masjid to join the jama'ah and the imam is in ruku' or in sujood and you want to join that jama'ah, make sure that you to make takbiratul ihram while you are standing up. It's very important because it is an essential component of the salah to make the opening takbiratul ihram while you are standing up. And this is the opinion of the majority of the scholars, the opinion of the Hanafi, the Shafi'i and the Hanbali, that it has to be done, takbiratul ihram has to be done while you're standing up. Because I noticed that some brothers, they were saying the takbir while they are moving and trying to catch the imam in the ruku'. No, make sure that takbiratul ihram, or to say Allahu Akbar while you are standing up. Then right after that you move to the ruku', and you don't have to say the second takbirah from making ruku'. That will take care of it. But make sure that the takbiratul ihram was said while you are standing up before moving to ruku'. طيب. Last week started talking about modern transactions, and we talked in details about credit card transactions, and inshallah today I will talk about another modern transaction we talked about briefly before, but inshallah I'm going to revisit it again, which is insurance or at-ta'min in Arabic. And insurance is a promise, or it's a guarantee, in fact, of compensation for specified loss or damage or illness or death, specified potential future loss, in return for compensation, which is premiums paid by the insured. So we have the insurer, the two parties of the contract are the insurer and the insured. The insurer is the insurance company and the insured is the individual. Okay, so the insurer promises the insured that in case if he is ill or any damage happened to his car, for example, or if he died, that a sum of money would be paid, or that damage or illness will be taken care of by the insurance in return of premiums paid by those individuals. Now, the compensation is paid from a fund to which all the individuals, all the insured contribute, like contributing, paying premiums for those collected premiums, then the insurance company will pay the compensation. This is the definition of insurance. There are the common types of insurance. We have the life insurance in which the insurance company will pay a sum of money to a beneficiary upon the death of the insured. Okay, this is life insurance, and the different types of life insurance. Like there is term life insurance, which the insured will be insured for a specific period of time, like 10 years. Okay, this is the first type of insurance. The second type of insurance is health insurance. In health insurance, the insurance company will cover the expenses of physical, or the cost of doctor's visits, emergency room visits, hospital stays, medicine, and things like that. Okay. Another type of insurance is automobile insurance. Automobile insurance, that the insurance company will cover and pay for the damages you cause to others or damages caused by others to you. And there are other types of insurance, like for example, house insurance, also appliance insurance, warranties or extended warranties of cars or appliances or other types of objects. Those are the known types of insurance. And we said the ruling concerning insurance, that insurance in general is haram, is prohibited. The life insurance is haram for two reasons. The first reason, that it contains riba, because usually the beneficiary will get an amount of money much more than paid by the insured. Okay, a policy that worth like $60 or $80 a month, you know, the beneficiary can get $1 million or $500,000. And this is like selling less amount of money for more money, which is riba. And the second reason for the prohibition of life insurance is al-gharar, which is uncertainty, because no one knows when he's going to die. Okay, this is uncertainty. This is gharar, which is also prohibited. But for the other type of commercial insurance, they are prohibited because of the presence of gharar, of uncertainty, because of gharar. Okay, now for those above reasons, there is under no circumstances life insurance would be permissible. Only one exception, if it's provided free of paying anything. Now it will be treated like a gift. If your employer provided you with life insurance, free life insurance, then it is considered to be acceptable, because it's not, in fact, it does not fall within the definition of insurance here. It is only a gift. Okay. But for the other types of insurance, there are certain circumstances where they could be allowed or permissible. Now, if the insurance is offered to you as a part of another contract, if it is like it is offered to you not as a separate contract by a separate entity, no, it is offered to you as a part of another contract. Like, for example, if you are purchasing a car and the dealer offered you an extended warranty, like you can extend the warranty, which is it's going to be as insurance, to extend the warranty on that car beyond, you know, the 3 years, for example, to extend it to 10 years. Okay, even if you paid separately for that, that's acceptable. That's acceptable as long as it is provided within the same contract, without involvement of a third party. Now, if, for example, Muhammad sold his car to Ali, and he offered him for additional price to extend the warranty of that car to 5 years, that's acceptable. But if Muhammad is selling his car to Ali, okay, and then Khalid gets in, which is a third party, to offer the purchaser insurance, that okay, I will give you an extended warranty providing that you pay me such and such amount of money. This is unacceptable. But if it is offered at the part of the same contract, even if you paid separately to it, that will be acceptable. Like also extended warranties. If you purchase a computer, okay, like at Best Buy or any other store, you know, they offer you extended warranty. That will be acceptable. Also, car rental insurance. If you rented a car, okay, and they provided to you full coverage insurance, if you paid more, like $10 a day, that will be also acceptable, because this is the same principle. This is one circumstance where commercial insurance becomes permissible. Also, if you need to have that insurance, like you live in a community or a place where the cost of medical care is very expensive, okay, because of that need, you can have health insurance. The same thing if the insurance is required by the law, like liability insurance for your car, then of course this will be an exemption and you can have insurance. Now this some related points to insurance, we covered it before. طيب, inshallah, today also I'm going to talk about another contract of exchange. If you remember, we said we have different types of contracts. We have contracts of exchange, we have the contracts of charity, عقود التبرعات, and we have the contracts of partnership. We covered for several weeks the contract of sale. Okay, we talked about the essential components of this contract. We talked about the conditions. We talked about the different options to revoke a sale contract. Also, we talked about the different types and categories of sale contracts. And also, we talked about the prohibited types of sale contracts. Okay, I'm going to talk now about the so-called عقد الإجارة. عقد الإجارة is a contract of إجارة. So what is إجارة? إجارة literally means, in fact in the Arabic language it derived from the word أجرة. أجرة means to compensate. As Allah subhanahu wa ta'ala says in the Quran,
قال لو شئت لاتخذت عليه أجرا.
قال لو شئت لاتخذت عليه أجرا. You know, if you have wished, then you could take or get a compensation for that. This is Surah Al-Kahf. So literally, ajara means compensation, or to take a compensation. Okay, as a technical word, as the jurists defined it, they defined the contract of al-ijara as using the benefits of an object or a property, using the benefits of an object or a property, or using surface or a surface of a person for a specified period of time in return for a compensation. Right. And all the essential components of the contract are applied here to this contract, because it's a contract. Again, it is a contract of using benefits of a property or using surface of an individual for a specific period of time in return for a compensation. طيب, some scholars, they get into very detailed types of definition, and the more you detail, the more you limit your definition, the definition becomes accurate. Because we said, you know, the scholars said a good definition should be inclusive, which means that it should include every element that belongs to that definition. But also it should be exclusive, which means that it should exclude anything that is foreign, that does not belong to it. Okay, so the more limits you put or limitations you add to the definition, the more accurate will be the definition. So some other scholars, they make a lengthy definition. They said هو مبادلة عين مباحة. It is the exchange or the contract of using a specific and lawful benefit. So they added two limitations here. Instead of saying using a benefit of a property, they said using a lawful and a specific benefit, a lawful and a specific benefit of a property, or using a service of a person for a very specific period of time, okay, in return for a lawful and a specific compensation. Okay. This is the definition of عقد الإجارة, the contract of إجارة. Okay. From the definition, you can see that it's a contract that deals with two things: leasing a property or hiring an individual to perform a task. So we're talking about either you lease or rent a property whether it is a house or a car or anything that has a benefit that you can use, or leasing or employing the service of an individual person, which is hiring. So it covers both hiring and regular leasing. Those are the two types of عقد الإجارة. طيب, the evidence for the legality of عقد الإجارة are mentioned in the Quran and the Sunnah, and also it is the unanimous consensus of all the scholars. It is the ijma' of the scholars. From the Quran, Allah subhanahu wa ta'ala says in Surah Al-Talaq,
فإن أرضعن لكم فآتوهن أجورهن وأتمروا بينكم بمعروف.
فإن أرضعن لكم فآتوهن أجورهن. فإن أرضعن لكم فآتوهن أجورهن. If they suckle the child, then give them their due payment. So this is إجارة. Okay. قالت إحداهن, this is سورة القصص.
قالت إحداهما يا أبت استأجره إن خير من استأجرت القوي الأمين.
قالت إحداهن يا أبت استأجره. You know the story of Musa alayhi salam, when he helped the two ladies. One of the two ladies, the daughters of Shu'aib, according to some mufassirin, she said to her father, قالت يا أبت استأجر إن خير من استأجرت القوي الأمين. Oh my father, hire him. Oh my father, hire him. So this is a hiring contract. Also in the story of Musa, as I mentioned earlier, قال لو شئت الخضر, Musa said to Al-Khidr, قال لو شئت لاتخذت عليه أجرا. When he repaired, when they come to that village and they asked the people for food and they refused, they denied them that service, and they found a wall about to fall, then he fixed it. Musa said, قال لو شئت لاتخذت عليه أجرا. If you had wished, you could have take a payment for that. Okay, so it is a known contract in the Quran, or mentioned in the Quran. من السنة حديث عائشة رضي الله تعالى عنها الذي أخرجه الإمام البخاري أن رسول الله صلى الله عليه وسلم وأبا بكر، هذا في قصة الهجرة، أنهما استأجرا هاديا خريتا، يعني حاذقا يرحمك الله. That the Prophet صلى الله عليه وسلم and Abu Bakr as-Siddiq, you know, when they planned to, or when they migrated from Mecca to Al-Madinah, they hired Hadi and Khirritan, a very professional guide, to show them the way to Al-Madinah. And he was an unbeliever, that guide. And this hadith was mentioned by Al-Imam al-Bukhari, and this is a hire or an ijara contract. Al-Ijma', you know, Ibn al-Munzir, rahimahullah, one of the greatest scholars, he mentioned that this is a unanimous consensus of all the scholars, that the contract of hire or the contract to lease a property or the contract of ijara is a valid contract. Now, what is the difference between a sale contract and ijara contract? You know, in a sale contract, or a sale contract is a transfer of the ownership of the sold item from the seller to the buyer. So there is a transfer of the ownership. Here, there is no transfer of ownership. You don't own the rented property. You own the benefit of that property. You don't own the person who provided the service, but you own the service. So this is a difference. But also it's considered to be as a contract of exchange, because we exchange a manfa'a, which is usage or service or benefits, in exchange it for what? For compensation. So it is also considered to be an exchange of a contract of exchange. But what are the essential components of Aqd al-Ijara? They are the same like the essential components of the Aqd of al-Bay', the contract of sale. He said the contract of sale has four essential components, right? The two contracting parties. Who are the two contracting parties here? we have the owner of the property, who is the lessor, okay? And the other party is the one who get the benefit, right? The lessor. طيب. The format, of course, of the ijara, that each one of the two parties should communicate or express his intention to, for example, the lessor should express his intention to lease the property to the lessee. Okay, and the other one has to accept that. So we need to have the offer and the acceptance. And of course, the subject matter here is the leased property and the compensation. So the four essential components of a regular contract is also applied here. Also the conditions, like, to be specific, deliverable, and all those conditions that we mentioned before, and also for the two parties to be adults and mature, legally competent, and the mutual consent of the two parties. All the conditions applied to the sale contract are applied here. Some related points that both the rent and the manfa, the compensation and the benefit, must be well known and specified in a very clear manner. Why? To eliminate any possibility of disputes in the future. Also, the manfa is the benefit of the property, and its period must be specified. The period has to be specified also in a clear manner. The rent and the manfa must be lawful or Islamically permissible. It is haram to lease something which is haram. Also to provide a service which is haram, which is prohibited. Now, if the rented or the leased property is a house, then the tenant can occupy the house himself, or he can take in it other people, other residents, unless it is stipulated in the contract that only the one who signed the contract is the one to occupy the property. Otherwise, if there is no such condition, he has the right to, for example, have other tenants and residents with him at that property. But if the contract mentions the name of the occupant or the tenant, then he does not have the right to sublet or sublease that property to another person. Okay? But if there is nothing like this, or no stipulation, then he has the right to sublease it to somebody who will use it the same way he supposed to use it. It is up to him, and the owner has nothing to do with that. If he rented the house, the tenant or the occupant cannot turn it into, for example, a workshop or a garage, except if the owner permitted him to do that. If he rented a house to live in it, he cannot turn it in something else like a workshop, except with the permission of the owner. The maintenance of the property is the responsibility of the owner. Okay. Now, if there is any damage happen to the property because of the tenant, like his ignorance, or he's not taking care of the property, then he would be responsible. The tenant will be responsible for the damages. But like damages that happens, like for example, broken pipe or something like that, or the refrigerator went, or damage or something like that, it will be the responsibility of the owner to fix it. This is the opinion of the majority of the scholars, that the maintenance of the property is the responsibility of the owner of the property. If the person who is, now this is for the second part of ijara, which is hiring a person to perform a task or to do a certain job. Now, if a person who is hired on wage or for compensation put a condition that he will work only to the one who employed him, then the employer cannot lease out his service to another person, like a contractor who had a contract, okay, to perform a certain job to a certain person. Okay, now that company cannot lease the service of this contract company to another company or to another individual. Okay, if he stipulated, if the contractor stipulated, or the labor or the person stipulated that he will only perform that task or that job for this employer. Okay, according to the majority of the scholars, it is permissible to sell a lease, such as taking money in compensation for vacating a property. If you rented a property, a brother is interested in that property, he can compensate you to vacate the property and get into the lease, or get into a new lease with the owner of that property. This is acceptable. Those are the important points regarding the contract of al-ijara. One point before conclusion of contracts of exchange, the so-called al-iqala. Al-iqala is the termination of a contract after the contract is concluded and after all the options to revoke the contract are expired. When you get into a contract, as we mentioned earlier, you have the option or the right to revoke the contract as long as the two parties are present in the same place where they conducted the contract, or if they stipulated a condition to extend the right to revoke the contract, or if there is a defect in that contract. Okay, now if all those expired, is there any way to terminate a contract? Yes, this is called al-iqala. Al-iqala is recommended, is to terminate the contract, but it has to be done with the mutual consent of the two parties. Okay, like if, for example, the buyer, after all his options to revoke the contract expired, he felt or he regretted that contract. He felt, he could have a better deal, okay, or a better object for that money he paid. Okay, and he asked the seller to terminate the contract. Now, the seller is recommended. It's not an obligation upon him. He could have said no. But he is recommended to accept the iqala. As mentioned in Hadith Abi Hurairah radiallahu ta'ala an, Man aqala musliman aqala Allahu asratah. Whoever, accepted to make iqala for a Muslim, Allah subhanahu wa ta'ala will lift some of his hardship. Aqala Allahu asratah. Okay, so it is recommended for him to accept that. Now, is the iqala considered to be only termination or considered to be a new contract? There is a difference among the scholars regarding whether it is a new contract or just fasakh. Fasakh means to terminate the contract. Now, what would be the consequences of this difference between the opinions? Those who said it's a new contract, they said the iqala could be to retain the same price or higher or less price. Like, for example, the seller could say, okay, I will accept your iqala, providing that you pay me more, or I will return to you less than what you had paid to me. This according to those who said it is a new contract. They consider it as a new sale contract, as if now the seller becomes a buyer and the buyer becomes a seller. Okay? But for those, and those are the Hanafis, who said no, it is only a termination, which means that you give back the object or the property and you will get back the price that you had paid before. Wallahu ta'ala ajallu alam. Inshallah, next week or tomorrow, inshallah, we're going to start talking about the contract to secure a debt. There are certain contracts in Islam to secure a debt. if a person, for example, borrowed money from you as individual or from a bank, the bank can have the so-called عقود التوثيق, the contracts that secure or ensure that the client will repay the debt. One of those contracts is عقد الرهن, which is the mortgage contract. Mortgage means to mortgage an object, and it will be taken in the custody of the lender to secure that debt. Okay. Also, some other contracts like al-kafala. Kafala is financial guarantee, and also al-wakala. Al-wakala is a physical guarantee. Inshallah, we'll talk about those types of contracts tomorrow, inshallah. والله تعالى وجل وعلم. سبحانك اللهم وبحمدك أشهد أن لا إله إلا أنت أستغفرك وأتوب إليك وصلى اللهم وسلم وبارك على محمد.